Here he is. The man, the myth.
Right, good morning. At this time, I want to open the legislative subcommittee meeting of the Ethics Commission at this time. For roll, Chair Wallen, I'm here, Vice Chair Duffrin.
Present.
And Commissioner Oscarson.
Honored to be here, Madam Chair.
Thank you. For staff, we have Commission Counsel Chase here, Executive Director Armstrong
here,
Associate Counsel Bassett here, Executive Assistant Pedroza here, and Senior Legal Researcher Hayden
here.
Right. Executive Director Armstrong, are there any members of the public who wish to comment?
we have not received any written comments, and I don't believe there are any on the Zoom. No.
Okay. Item 3, identification of proposed legislative priorities for inclusion in the Commission's bill draft request for the 82nd legislative session 2023 to amend NRS Chapter 281A, Nevada's Ethics and Government Law and related considerations. At this time, I would like to call the item and ask our Executive Director for a presentation.
Thank you, Chair Wallen. In the packet, there's a document titled Reference Guide to AB 65 provisions that we'll be walking through during this meeting. As I think the commissioners are aware, AB 65 was our ethics bill last session. It then was amended through amendment number 777, passed both houses, and was vetoed by the governor. And so what we've done is we've taken that AB 65 as it was and identified for you as commissioners the staff recommendations kind of in 3 tiers of priorities for a new BDR. Those in tier 1 are in blue and are recommended for inclusion to be maintained in the next legislative packet. Tier 2 are things that would be nice to have, but if there's some reason that they're overly controversial or burdensome, that we can live with waiting if we need to. And then gray are kind of the lowest priority or maybe consider some substantial changes from the last session. So I will walk through it, and I think after each section, I'll pause and see if there are any comments or discussion. So 1 through 6 of the bill was definitional cleanup. We'd recommend keeping those definitional cleanups. Section 7 clarified the application of the ethics law, and it confirmed that the commission has the ability to consider kind of whether one or more prongs of the ethics law were violated in any given set of facts. Are there questions about that first section at all?
No.
Section 8 it basically mandated that there be reasonable assistance and cooperation of public officers and employees in the commission's proceedings. And as it was amended by Amendment 777, it excluded the subject's attorney from that duty to cooperate. So that was a discussion that they had in terms of like, how can you force somebody to cooperate when their job is to try to essentially defeat our investigation. And so in taking a look at it, we think the commission should consider removing that section. In my look at it, there's already provisions and penalties that can be assessed if someone is actively interfering with an investigation. And so having kind of this, like, oh, you have to cooperate, I don't know is necessary given our investigatory powers of being able to issue subpoenas and depose people. So I'll stop there for section 8 if there are thoughts on that.
Yes, I'd just like to add to it. This was one of the provisions in the last session that did have some really strong local comment as well. And I do believe legally, like the executive director indicated, we have tools, subpoena powers and everything else. And so, if someone is reluctant to testify, it's better actually to put them under oath and take it that way than receive their cooperation, which may not be a full cooperation. And we just have better tools available as well, and we would lessen the controversy in the bill.
Yeah. Fellow commissioners, you agree?
Agree.
I do.
Section 9 of AB 65 created consistency between the ethics law and the open meeting law regarding litigation direction on judicial review. I don't know, Commission Council Chase, if you have anything additional on that.
I do. Actually, in the last legislative session, both the executive director at the time and myself went to the open meeting law task force. And we had provided language for that task force to actually allow us to have confidential legal sessions based upon delegation of authority to the chair and have the chair direct us. And that came out of, unfortunately, the Hanson and Weaver case where the chair directed litigation. That being said, we are just creating it consistent with Nevada's open meeting law. There was no controversy in the last session related to this amendment, and we're recommending it be maintained.
Commissioners, good with that?
Sounds good.
Okay, the next item I think is a good one to have some good robust discussion on. So section 10 created an additional code of conduct for gross or unconscionable abuse of power. And so this added a new violation to the ethics code. Most of our ethics code talks about benefiting yourself as opposed to harming someone else. And so this provision would have added this conduct for gross or unconscionable abuse of power. And so some notes there, I think in talking with Commission Counsel Chase, just trying to make sure that there's really clear direction on what that might be to reduce litigation and interpretation. So I will toss that one out there for some discussion on that item.
Yes, Commission Counsel.
Just to add to the thoughts, Tracy Chase for the record, Commission Counsel. This was a provision where LCB basically created the language for us. I do have some legal concerns. I mean, what conduct is actually a violation? Is it going to increase complaints on my supervisor has been mean to me? Those types of nebulous complaints. So like an abuse of power, do you have a power to actually be mean to someone in the employment scenario? Are you having animosity, or are you actually just doing your job to be a tough supervisor, perhaps, in a situation? We have had prior cases where we thought this would be a useful tool as well in some of those cases, where we had public officials that basically were denying licensing issues just because they did not agree with, or they had some type of animosity toward the person who was requesting the licensing. But I see that as a more of a singular or a limited type of occurrence. I do think that this might open up the gates to where we're looking at legally, well, should this conduct really be within the statute? So that's why the executive director and I talked about it. And if it's going to be included, we really do need some really good definitional provisions that tells us what the conduct is being regulated. And that's only fair to the public officers and public employees as well. So, it's kind of in the middle. We're recommending, if you're going to keep it, to maintain up. We'll see if we can get better definitions from Legislative Council Bureau and work with them on it. And also, I don't know with the changes in LCB whether or not they'll support, the provisions that they provided before or not.
Fellow commissioners, comments? Vice Chair Dufferin?
Yes, thank you, Madam Chair. So I think this might have been one of the items that for some of our legislators, last time we met with them, they had some issue with when they said that we were trying to add to our powers. So I think this was one of the items that they had concerns with. I'm fine leaving it out this time. We have so many, I went through and counted the recommendations by staff. I know we haven't gotten to all of them yet, but if we end up voting for all the blue items, there's going to be a tremendous amount of items in this bill. I don't necessarily think this one's the most important one that needs to be included, so I'm fine leaving it out at this point for those reasons, because once again, I think we have other fish to fry, so to speak. So I'm fine leaving this out, but I'm also open to hear what the other commissioners have to say.
Mr. Oscarson?
Madam Chair, like Vice Chair Dufferin and our council, I think it's very broad. I think workplaces have, in many instances, the ability, and other commissions have the ability to look at those kind of things. If we're specifically talking about animosity against a person, I mean, what, like the executive director said, what constitutes animosity? What is the definition of animosity? It's like the definition of moral turpitude at these days, times. What is that really? And who determines that and what determines that? I don't think it's our job to do that. I think it's our job to make sure that, you know, that public officials act in a manner that's appropriate and consistent with their duties. Could there be some place for that at some point in time? Perhaps. But right now, I think certainly the legislature has enacted some very stringent rules and things for their members of the legislature. Other members, you know, you'd hope their boards and their district attorneys and those kind of things across the state would look at those kind of things as well. So I would agree with Commissioner, with Vice Chair Dufferin that it probably is something that we can table for now.
Okay, this was something, you know, I had a little star by it. And I think we need to have something like this. And when you brought up, oh, well, harassing somebody or being mean to them, well, that falls under the labor laws of, you know, harassment. So that's, you know, no brainer right there. But I really have a problem when there, and we've had other cases that have come before us and we've just had to say, sorry, it's not in our jurisdiction. And I have a real problem with somebody abusing their position because maybe they don't like somebody. I mean, you could abuse your position if you had a friend in a licensing board. Say you have a friend and somebody comes to get a license and that person is being competition with your friend and you deny the license or something like that. And I just, you know, I think I agree with my commissioners. You know, I saw these things in blue. I was thinking that we'd see more in gray, but there's things we really, really need, you know? So I guess I will go along with my fellow commissioners to table it this time. You know, and maybe we can get Commissioner or Assemblyman O'Neill to add it to his bill or something, you know?
Madam Chair, as a thought to maybe assuage your concern, what we could do is we could go back into the definition of a commitment in a private capacity. And we could broaden that to long-term substantial friendships.
Yeah, but
And then
The-
that would be
the situ-
captured
the
throughout the
decision-
ethics law.
I know, but I'm just saying the situation that we have right now with, or the situation where we had a complaint and we couldn't do anything, that was very egregious. And there was no commitment in private capacity there.
I do think that when people come to us, they think that they come to us, they see bad government out there, right? Whether they're frustrated because they don't get their unemployment check, or they get all sorts of people that, you know, we take phone calls from. And I think there is this gap where it's short of some sort of like 1983 civil rights violation that the government officer is doing, but it's still bad conduct for bad motives. And that's where people get, I think the general public gets frustrated with us saying we can't do anything about it. So I think I think thinking about it some more and
So is there middle of the road, Russ?
no, like I was looking at the actual language from last, and this is where I was like, I don't even know what this really means. I remember this from my interview process, but the language as it was written last time says a public officer or employee shall not use the public officer or employee's position or power in government to take any actions or compel a subordinate to take any actions that a reasonable person would find based on a given set of facts and circumstances to be a gross or unconscionable abuse of official position or power that would undermine the integrity or impartiality of a reasonable person in the public officer or employee's position under the same or similar facts and circumstances. And then the part where we talk about if we do go forward, we need definitions. This is what they said. they kind of did this does not mean. So the provisions of this section must not be interpreted, which would be interpreted by the commission or a judge on judicial review, to apply to any allegations claiming only bias, error, or abuse of discretion in any findings, decisions, policymaking, or other actions taken by a public officer or employee within the normal course and scope of his or her position or power in government. And so I don't even know, based on the language from last time, if the licensing example would be covered. I think it would be excluded.
Well, and I look at it, elected officials, which, you know, there's some jurisdictional issues there, but elected officials have to be responsive to their constituents. And there's a thing called elections that change that if they feel like they have been inappropriate or done things and it's proven out through their constituents that those kind of things happen. So, and that goes for, I mean, you talk about elected officials, that's a huge group of people. That's not just legislative people, that's boards, commissions, sheriffs, I mean, all these people that exist are appointed people. So I think that I think there's some room for, as the chair said, some interpretation of that, but that's far too complicated.
Yeah,
Yeah.
I mean, if you guys can't understand it and you're attorneys, how am I supposed to?
I mean, I used to get pretty good at understanding some of that stuff. You know, granted, I haven't done it for a little bit, but that makes absolutely, it to me, that contradicts itself 3 or 4 times during the entire process. And again, I'm not a lawyer. I never went to stayed in Motel 6 once, but I didn't get to go to law school. So I think that's just far too complicated. And if you want to come up with something at the chair's direction, something that would be simplified, that would be more common sense kind of things. And I think that's what we got to look at. We got to look at common sense kind of things. We have to look at what our job is, and that is to make this understandable for people, not fend them off and ward them off. You look at that and you go, holy mackerel, how am I ever going to prove that?
Right.
And anybody's attorney, you know, I wish some of our other attorneys were here, but they'd look at that and say, what the heck?
Well, and if you're a public official and you look at that, and you're trying to comply with the law, like how do you not violate that?
Well, how do you explain that in
Right.
a training?
Yeah, it's a tricky one. So we can certainly say, okay, if we want, we can think about kind of those examples that have been frustrating in the past and see if there's a more straightforward.
Isn't there something, maybe you could do some research, or LCB could do some research for you if they will do that, about the behavior and the commitment of a public and elected official and how they do things and simplify that, because I know it's not that difficult. And the things that I've read and the things that I've signed and done, it's not that hard.
Maybe even Kogel might be able to.
Yeah.
Maybe they might have something that would make sense. Other comments?
I don't want to throw it out. I don't want to throw the baby out with the bathwater, Madam Chair, but I think that there's something to be said for this. But I think the way it is
Oh, yeah. the
to
way
me
it's
is so
written, it's like,
convoluted.
yeah,
It couldn't be.
I mean, it's.
And I defer to Vice Chair Duffer and to give his usual logical wisdom of these.
Well,
matters.
I would add, Mr. Oscarson, Commissioner Oscarson, that just the term unconscionable, the legal term has so many different definitions.
Right.
I know in my experience working for the state of Nevada that we had, you know, a human resources manual, a personnel manual that dealt with some of these issues for behavioral issues that were abuses of power. And so on some level for employees, this is a employee human resources issue. It's a performance issue. For public officials, maybe not so much, but I think you kind of hit it on the head when you talked about being reelected and abusing your power as an elected official. But yeah, I think there's something in here. I think the chair is correct when she is concerned about trying to find something in here that we could use to help our cause and help our mission. But I just can't find it with what's in here right now. I think there's a lot of work that has to be done on this particular section. So I'm kind of punting it at this point, only because I think there's a lot of work that needs to be done on this. So those are my additional comments.
I would ask that you don't include, on a previous board I sat on, we had a very hard time with a large group of people trying to determine moral turpitude as well. What is moral turpitude? There's really no clear definition of moral turpitude. That's why you go into these big, long explanations of what and how and when and where and who and all those things. Got to be, I think that there's resources we have available that would help us. Other states have to have faced similar kind of things, and we could certainly look at those as an option. So, thank you.
Okay.
Madam Chair, just to clarify, at this point in time, do the commission members agree to table this, but we'll see if there are options that we could find to
Yes,
bring
we-
it back, because we do have a limited time to provide this information to LCB. It's got to go in the middle of May, so it's a very short time period. So that tabling and options, just for your information, may come into the next legislative session. But we'll try to see what we can
Yes,
do
see
in
what
the
you can
interim.
do. Like I said, maybe reach out to Kobo. That
Yeah,
might be a-
we'll try to see what we can do in the next couple of weeks, but I just wanted you guys to know we do
Yeah.
have a very compressed timeline.
Madam Chair,
Yes.
are we planning, is this committee going to meet again before that? Because,
Oh, we're gonna meet probably another couple times.
I mean, are they going to meet before what Commission Council just mentioned, the timeline where we need to kind of dial all this down? We're going to meet again before that?
Well, we have to have this approved by the full commission, right? So
Yeah.
by our next meeting, which is May 18th.
Yeah. So I would imagine you can probably, I would imagine a meeting that first week of May.
Yeah,
And
definitely.
I think you might be able to get it all done with one more meeting, but you might need a second one.
Mhm. Yeah, so we will definitely have another meeting, like the first week of May, and then if we have some fine tuning to do, then we have another meeting before our commission meeting.
Yeah, so if we could table this until our next meeting, and if you want to do a little bit more research for this committee, so we can haggle it a little bit more, but
Yeah,
So,
before
yeah,
we throw it
because I think there's some substance in here. I'm just not sure at this point if we're really looking at it yet.
Okay. That will
Agree with
be-
that, Russ?
Yeah, that'll be our plan.
You sure, you
Yeah.
okay with that?
Yeah.
I mean, I know you mentioned that it's even hard for you to kind of understand.
It is. I do think there should be a spot for when there's, and the notes I was taking is we have that one section about unwarranted benefit, and I wonder if there's a way to flip that and have a provision about unwarranted harm to someone. So that's kind of where I was already
I like it. I like what you're
thinking
thinking.
about.
Okay.
Section 11, we have those annual acknowledgement, or not annual, but those regular acknowledgements that have to be filed. Currently, entities have to submit who those public officials are to the Secretary of State. So this just adds that requirement. So they send us their list of public officers that would be covered by that. We did some kind of compliance checking this last season for acknowledgements, and it was really me Googling like each school district to find the name of the superintendent to then find out if they'd done their thing. So if we are able to get a list, we can cross-check with our acknowledgement database and find out who's not citing. So that's what 11 is. Any questions on 11?
I don't have any questions. I mean, I just have one comment though. Like right now, if you don't file, what happens? Say you need to file and you don't have fines or penalties, but that's a little touchy issue.
Yeah, it is a violation.
Mhm.
And so you can always file complaints against folks who haven't
Yeah,
or refuse to.
but I
So
just soon try to get people more in compliance.
yeah, I view it as like your annual physical health check, right? Like every time you go have to fill out that form, you hopefully go take a look at the statutes and make sure there's nothing new there.
Does the Secretary of State's office not follow up on those?
They do not follow up on our filings. They only follow up on their financial disclosure statement filings, which they have independent authority to
And
take.
there was a recent article that they don't have the staff to even review those. that they just received them. So that's 11. 12 would have allowed the commission to provide information during an investigation to state or federal law enforcement agencies. Currently, it's confidential, and so I think some of our most recent litigation was defending requests for information. And we did not really see this as a super high priority item, and would say just to consider eliminating. I know this usually falls on Commission Counsel Chase to defend us when those requests come in, and so I don't know if you have anything else.
Not to say that there isn't potential criminal conduct associated with the same fact patterns the commission is receiving. Certainly they do, but with our confidentiality protections, we're very much hindered from providing our investigative file or anything else to any third party. So that's the concern. How effective is it going to be? I know we do already have a statute in place, NRS 281A 790 subsection 7, that at the end of the case, if you guys determine that there is criminal conduct, and you guys have in the past referred it to the appropriate agency. We referred a case a couple years ago to the Attorney General's office under that statute because there might be criminal conduct. And even when we referred that, we never got any information back as to what happened to the case because that agency also has similar confidentiality protections. So it's very difficult to navigate what you can and can't help with, number one. And it places commission staff in a position where they really would like to help, but they're precluded from helping. And you really can only give the public documents. You couldn't give our internal interviews or things like that anyway. So it's very much a difficult kind of line to even know. So I was kind of just recommending eliminating it at this time. It's not a high priority.
Can they not be subpoenaed?
Our
Those
records,
yes.
no, I defend them in court. If it's a confidential record, they can't be subpoenaed. They're not available to anybody. There are exceptions. For example, the litigation that I was in the recent past, they were asking for records about a particular subject that sought an advisory opinion. And the court determined that that subject, through their own actions, waived their right to confidentiality. So, but I was able to protect all the commission's confidentiality, meaning our attorney-client processes, our processes in attorney work product and doing the case, our internal investigation, if we had any in the file, all of that was maintained by the courts and determined to be protected by our law. What wasn't protected is all the information that that subject gave to us.
Well, don't we, so in this section, we also have that provision that say we get a complaint and it's not in our jurisdiction, that we can send it, we would be allowed, even though it's confidential, to send it to like a EEOC or another department or agency that this applies to. Because I think our thought is, we get cases sometimes, it's like, well, that's not in our ball court here. And wouldn't it be doing a service for that person to send it on to the appropriate agency?
I do think that's a great service. However, my thought was a little bit different, that we do, like if it's a personnel matter or a NERC matter or EOC matter, we usually will in the orders or in our communications refer them to that agency.
Okay.
Because that agency will want original information from that person. Our agency can't start an administrative complaint for another agency because we're
Right,
not
yeah.
within their parameters. Just
All
like,
right, just as long
So
as
that-
long as in the orders that we're doing that to say this isn't in our purview, please, and give them the contact information, don't say contact this agency.
actually, we're really good about that. You haven't seen a lot of communications our new executive director is doing, but he gives them connections through email and everything else. If people are
good.
contacting us about an issue, we do try to get them to the right place whenever possible.
Another question I have is, as these become public, we do something that does become public. Why wouldn't another agency be able to look at that and start their own investigation?
Sure, at that point they can, and all that we would cooperate and provide to them. And we do have a statute that once those cases do become public and you make a decision, you can refer them and then we can give them all that public information.
Okay.
We have a statute that permits us to do that now,
Okay.
and we've done it in the passed.
Okay, so this is just expanding.
I'm okay, yeah, I'm okay with
I'm okay with just pushing that back.
Vice Chair Duffer.
I'm fine with that.
Sections 13 and 19 were cleanups. 20 is kind of like a bylaws change, but it's going to be in our NRS that the vice chair may perform the duties of the chair in the chair's absence. Section, are there any questions about that one?
I may want to talk about that.
Yeah, I thought you.
It depends on who the vice chair is.
Right.
The current one.
Section 21, we currently have implemented a few times this settlement process, and this would just formally authorize that process in statute. And so this has occurred post-panel before adjudicatory hearing, where a member of the panel serves as a settlement mediator and brings the parties together in a traditional mediation setting, where you kind of meet together and then separately and try to come to a resolution of the case. So this would just really formalize that process in statute, clarifying that that is an allowable procedure. And primarily that we can have a member of the panel participate in that way.
I really like this because I think it's consistent throughout the judicial system is how they do things. So I like that.
Vice Chair Duffer, comments on that one?
Well, my only comment is we kind of do this already. We're just formalizing the process. Is that my understanding?
Yep.
Mhm.
Thank you.
Section 22, we're recommending to get rid of it required that the executive director be an attorney licensed to practice law. This was a big issue for the legislators
Mhm.
in the last session, and I think they basically said if the commission thinks it's that important, they can take that into consideration when they make their hiring, but they didn't like that it was going to be in law.
I have no problem with it.
Section 23 and 4 had some cleanup language and really clarified the boundaries of representation for commission counsel, really with an eye towards making sure that there's due process rights for the parties in the process. Section 25 established a 2-year statute of limitations on advisory opinions on past conduct. And I think Commission Counsel Chase, is the lead on our advisory opinion process. And so you had some revisions that made sense to you on that one.
On this one, obviously the 2-year statute of limitation, it's a wish, to be honest, but there is a typographical error actually in the bill that says that advisory, I'm trying to remember if it's on this one or the next one, that the advisory opinions must be in a public meeting, which is incorrect. It's just a typographical error. So this is a wish, but you can leave it out if you'd like to. I don't really think the 2-year statute of limitations has been a large concern at all in advisory opinions, because they're asking advice for the most part on what occurred in the future. The other thing is on advisory opinions, we did get an en banc opinion, and I'd like to check the language that said in a confidential case that past conduct is not subject to judicial review. It's already occurred. Can't change the conduct.
Yeah.
So that if that is in this section, and I apologize, I don't recall at this point in time, that I would like to keep that because that's consistent with the Supreme Court opinion we received.
Okay.
So it's a wish and it's got a little cleanup, but it would be nice to include.
So that's one where we can come back at that next meeting.
Yes.
We'll share what
Thanks.
we're going to do on it. Sorry. 26 permits a court reporter to administer oath. Currently, it's just chair or vice chair. In all other proceedings, you have the person who's there, that's the recorder,
Yeah.
take the oath.
Well, okay, so do we want to add something, we're trying to pare this down. And it's not like
Yeah, that's why we have this orange,
To me-
because it's like,
To me, it's like, you know what? I don't mind getting rid of it because
Truthfully, I don't think legally they have a challenge whether a court reporter or the chair actually administers the oath. They're still under oath because the court reporter has independent authority to administer oaths.
yeah,
So if you want to keep it, that's fine, but it's something that we said, we both agreed, the executive director and myself, that this is one you could just leave out.
yeah, I vote for leaving it out.
Why can't you just go to court reporter school?
No, I'm still working. Vice Chair Duffin can go to court reporting school.
okay,
I'm
so
too busy.
So,
We don't need this in here. The
Alright.
chair and the vice chair can
agree.
do the oath. It's very simple.
Yeah,
If it's not simple, then the commission council will school us on it.
And in addition, let me add to that, I can school you that you have implied authority. You are administering it by causing the court reporter to provide it. I mean, I have a legal argument anyway that we can continue the practice we have done in the past.
I think when we
Okay.
put this in originally, we were trying to put everything in the kitchen sink we possibly could. And I think I think we're trying to clean up the kitchen sink.
yeah.
27, so we'll mark 26 for removal. 27, clarify that we could subpoena personnel records for public officers and employees relevant to the ethics complaints. And so it allows us to get what we need out of those personnel records, but maintains them in our confidential investigatory file,
Mhm.
unless it becomes an exhibit later on.
I think it's helpful to have that.
Section 28, we recommend for eliminating. It's really an additional service. It allows the commission to accept requests for advice as a referral on behalf of a public officer or employee whose conduct is at issue. So I think in talking with commission counsel, Chase, the idea was that you could have a local ethics committee or an attorney submit a request for an advisory opinion, instead of just having the actual public official do it themselves.
Well, I think in addition, it would be like if a local ethics committee was considering a matter and they could say, well, I think this matter really should be at state ethics for consideration and then refer it. But the reality is when that occurs, the individual comes and files anyway. It's really, it's a very helpful provision, I guess, but you really do want the individual asking for the advisory opinion to work one-on-one with us so I can ferret out the facts for that advisory opinion. And this creates another layer, which is needless because the individual can just come and request the advice.
Yeah, and then, it gets lost in translation if they're trying to interpret what this individual is asking for. So I vote get rid of it. Fellow commissioners?
I concur.
Yeah. Concur.
Section 29 clarified, you can't use government property or equipment or time, and there's a limited use exception. One of the prongs of that limited use exception is that there's a policy in place by the person who has the authority to have the policy. This clarifies that it had to be in place at the time the conduct occurred. I guess we've had cases where once the public official finds out that they can use this as a public use exception, they then go make the policy after the fact and then use that as evidence that what they did was fine.
In addition, we did have a case that went through that the commission determined there was a violation of this statute because the individual said, well, I have authority to create the policy, therefore I can create it verbally. I can create a policy that would provide me a personal benefit in use of government equipment. So we just wanted to clarify that, no, those types of conduct would not be permitted under the limited use exception. So based upon the case, and we've had this come up as a defense before, and it's never been a prevailing defense, but I think we can just wipe out that type of defense to these cases because it's not appropriate to create your own policy.
Yeah. Well, that almost gets to the abuse of power.
It does. So this might help you ease some of that we do have other provisions to help with
Yeah.
that.
Mhm. You guys agree?
Yes,
30 is miscellaneous cleanup language. 31 clarifies that, so we're talking about disclosure and abstention statute here, that 281A420. And it says you don't have to disclose otherwise confidential information if the disclosure is made about non-confidential information and if you've recused. So essentially it clarifies that the duty to disclose does not extend to making you disclose confidential information. If there's other reasons for you to disclose and that you recuse.
And the commission should be, we actually have prior commission opinions that required that disclosure. So, I mean, for example, if I'm a lawyer and I'm doing a disclosure, right now, our disclosure provisions would require me to disclose confidential information, which it isn't appropriate. We don't want to cross the line into professional duties in that regard. So that's what this is intended to do.
I had one comment on this one.
Mhm.
I think I read it maybe 10 times and was kind of confused. So maybe if this could be reworded. I think the term otherwise confidential, I don't know, I had trouble understanding what we were trying to do here. and you just explained it very succinctly. So I don't know if we could rewrite this for going forward on the next meeting, just so it's more clear.
I have a suggestion off the top of my head is that we could say if it's otherwise made confidential by a statute or court order.
Okay.
Yeah, we can take a look at that language and the actual.
Thank you.
statutory. So 32, we were talking earlier about the violation for not completing the acknowledgement form. And it replaces willful with refuses. And so it kind of raises the bar on someone for penalizing someone for not completing the form.
I think part of this was a wish list, if I might add to the executive director's comments, because we were really trying to, in AB 65, to secure compliance. And I do think if we do get a list of public officers that are required to file our forms, we can send a notice, and that's consistent with the prior commission direction to give them a chance to file, give them a 30-day notice. And then if they don't file at that point in time, we have authority to bring an ethics complaint by motion. So this was, I think that it should be like, if you're going to keep it as a complaint matter, it should can follow the process of any other ethics complaint matter, because we'll give an opportunity to cure. If they don't cure at that point in time, then it should go through the regular process, would be my recommendation. So this is a wish. It's not really.
I think we need to do the first step first. Let's get the list, okay? And with the education and stuff, and with what the executive director did when he was sending out tweets, hey, don't forget to file your form. We're starting to get the message out there. So I think I'd remove it for this, and then next session, think about it, because by then we've got a couple years under us to, get more compliance. And if we're not seeing that we're getting more compliance, well, then we need to step it up.
So let me be a little bolder than that. If the Secretary of State's office is not going to enforce this, or doesn't have people enforce it, all they do is send out the form, and whether it comes back or not is, I'm sure it's important. Why are they even doing it? Why don't we do it?
Well, we used to have, Secretary of State has financial disclosure forms. We have acknowledgement
So
forms.
why aren't we doing this instead of them?
The financial disclosure
No,
forms?
no, you're talking about the other form, right?
Yeah, we do it.
Right.
We
okay.
do it. We just don't have a list of public officers and public employees unless we do like a hand
Google.
search or.
So I
They're-
can't tell you.
But they're sending it out. Secretary of State's office is sending it out, right?
Not for us, no.
Okay.
No. I think we used to do the financial stuff and then they shifted over. But the issue now is, if you were to ask me, what is our percentage of compliance with acknowledgement forms for public officers? I have to tell you, I have no idea.
Right.
because we
Yeah.
just,
Well, it's a discussion for another day.
Yeah.
But I'm just saying, maybe there's some of this stuff that we should be doing.
Well, I thought, doesn't the Secretary of State get a list of boards and commissions and who should be filing?
They do, right now, I think the clerks of the different agencies have a duty to report to them a list of public officers, and that's all we were requesting, a copy of that in the prior one. And I think we would have the tools in-house to secure compliance
Well,
at
why
that point.
can't we get a list from the Secretary of State?
We could do a public
Because to
records
me-
request.
Well, why can't we just have a thing that they submit the list to us? I mean, why? I mean, it's not like a big deal for the clerks of various places to send the list to two different things. It's just hitting two different email addresses, but I just,
Well, then you're talking about staff to do it.
well, yeah, so that's section, I mean, that's section 11 that requires that list to come to us. This is a different piece of that acknowledgement.
yeah,
Form.
yeah, I know.
And there was some discussion about, would you want to, like the Secretary of State does, have a monetary fine for failure to
Yeah,
comply?
then you gotta go into.
I think
And I don't
this
think- I
session-
I
think
think
well,
you're
I
I
think-
think you're 2/3.
Yeah.
2/3 thing, and then it's probably.
I think this session, no, let's not. Let's
So,
just get rid of it.
What I'm hearing is the consensus is 32 removed from this next year.
Vice Chair, you agree?
I agree that it needs to be removed, but I also think this is a project that needs to be undertaken by staff to take a look at the form. There's just in preparing for this meeting, I went on our website and there's a lot of different forms out there. And maybe I'm just, once again, I like to find stuff that doesn't belong, and we can have this discussion offline, which we'll do after this meeting's over. But I mean, we allow people to file forms online, which is a wonderful thing. And then there's also links on here, which looks like one's for public officers, one's for public employees. And they're all different, like fonts, they're all different. It would be confusing for me as a public employee or official to say, okay, how do I do this? Even though we've all done it. I'm not making excuses for people that don't file them. There's no reason why they shouldn't file them. And I think most people would file them if it was super easy. And I think it really is super easy. I just think we need to kind of look at this whole process and make sure that we have a very uniform form and we have a uniform process on how you go about filing these forms. But I don't think there should be any kind of penalty via willful violation for not filing the form. I mean, there's a reason why this thing got on the books to begin with. The whole point, in my understanding, is to educate public officials and employees about the ethics law. And this signing this form acknowledges that they're aware of it. So they can't come back to us someday and say, well, I didn't even know you guys existed. You know, I didn't even know I had to file a form. So going down that rabbit hole, I think we just kind of need to take this on as a project and make sure that what we're requiring is we're being efficient on how we administer this form process. But I don't think number 32 should be included in our bill. Thank you. Starting to feel better.
Section 33 really seeks to narrow the scope of the cooling off provisions so that your individuals in agencies like your administrative assistants and other individuals who didn't have anything to do with the contracts that were awarded don't get caught up in a prohibition on going and finding other employment. So I know that was some feedback that was received during the 2019 session about how broad the current cooling off language is. And so 33 narrows it. I think it makes sense to keep it and it's some of a recognition of the different, the new kind of labor force and market, and people don't stay at a state agency for 30 years anymore. They're, or any private entity, people bounce a lot more now. So our recommendation is to keep section 33.
I'm good with that, and I agree.
I'm good with that.
Duffer?
Thank you. I agree.
34 is miscellaneous language cleanup, which is, I think, and Commission Council can correct me, is code for LCB, said they needed to change some stuff for their stuff. So
Yeah, and LCB is always in charge of those types of sections once they get together or final drafts. So
Okay.
and so the section 35 essentially clarifies a process that we already do and make sure it's clear in law, which is that there's always a back and forth with Commission Council and someone asking for advisory opinion to make sure that we have all the right facts. And so this just clarifies in the law that the 45-day deadline doesn't start ticking until all the facts are received from the individual requesting the opinion.
It's fair enough.
we do, so you know, have a regulation that helps somewhat with this, but this would be good to have it actually clarified in state law.
So section 36 is a substantial one, and it has a lot of different subsections. So subsection 1 allowed the commission to grant extensions on the statutory deadlines to issue advisory opinions. Beyond that 45-day period. It also allowed the commission to stay advisory opinions when we receive a complaint. Sometimes someone who's a subject of a complaint gets wind that somebody's getting ready to file a complaint against them. And so then they'll ask for an advisory opinion on the same topic. So this would say, if those come in at the same time, we deal with the complaint before issuing advice on something that the commission's about to rule on through the complaint process. The section 3, so we think 1 and 2 is good. 4, I think, is that en banc order you were talking about earlier, Commission Council Chase. For 3, it had establishing a process for informal advice to be rendered by the executive director or commission council based on what we think is consistent. It required there to be like a written record of that informal advice. And so we really took a look at capacity and right now if someone calls and asks a question, we can point them to the right law and say, talk to your attorney, or you can ask for a full-blown advisory opinion. I think this was to try to make it so there was essentially like an ethics hotline for public officers and employees, and we weren't sure we had the capacity to take all of those calls and appropriately process them. And so we considered either removing that or limiting it so that it's, an agency counsel that has the ability to call us up and ask questions so that they can appropriately advise their client. And so we're open for discussion on that particular one.
Comments, guys?
I'm good.
Well, do you want to limit it? We would want to limit it to commission or to the agency's counsel.
Just some additional thoughts for your consideration. Oftentimes we'll get these citizen calls and they'll say, well, I have this fact pattern, and they provide you the fact pattern. We already will identify for them. We can't give legal advice, but we can act as a resource. We already will identify for them where to find the ethics law, perhaps which provisions they might want to look at. We will pull any opinions that we know that might be related to those facts. I mean, we do give a substantial amount of assistance. Now, I think the concern with informal advice, because it also creates this appellate process up to the commission and everything else throughout the bill, is that really what you're doing is having staff given an administrative order at that point in time saying, this is your compliance obligations under the ethics law. I think that's terrific if you have time to do that kind of research on individual callers coming in. The amount of time that the executive director and I spend now on these calls per individual, I think is pretty significant. I mean, sometimes I've spent 8 hours providing information to an individual. But I think if you're heightening up to a higher level, it's going to be a lot more. You have to make sure that you've researched all our opinions. It's like just doing a full-blown opinion, but at an administrative level. And that's what we would be doing. The other concern I had was we have to keep track. We have to know exactly what facts are accurate on which we're trying to provide that informal advice. Because oftentimes people will call and say, I'd like advice on my disclosure and extension requirements, but they don't give you the full picture of the situation or the potential conflict. You could be on the phone for an hour asking, well, what about this fact? What about that fact? And so it gets very detailed at a certain point in time. We do provide assistance, and we do provide a lot of assistance to our inquiries that come into the office. But this would ratchet it up to a stronger level of informal advice that actually has appellate proceedings with it.
Because I thought last session, when we put this in there, that this would have been easier than doing a full-blown advisory. So now I'm hearing that that's not really true.
I think it's easier than doing a full-blown advisory opinion if you have staff that has worked with the agency for over 10 years. But given the transition that all agencies, including ours, has experienced, it's very difficult to put a new staff member in a position to do this.
All right, fellow commissioners, comments on this?
It sounds to me like we don't really need number 3. Sounds to me like we're kind of doing it already informally. We had this in there originally. It was just to, once again, formalize the informal process. I'm comfortable just leaving it alone. As I liked what I heard from Tracy about why she wants it not necessarily in there, but so I'm fine with 1, 2, and 4 and leaving out 3.
I am too.
And to add to the consideration, I know when I went to MLOT, there are agencies that have a hotline. And I talked to some of the individuals that answer those calls. And I said, well, how can you make sure that you've got your facts down so you're actually applying the law in an appropriate manner? And they said, it's a big issue. We have processes where we have to detail everything. And once I talked to that individual and got all the information they do on their hotline, it was pretty substantial. So I don't know whether the amount of individual staff work realistically would save time after speaking to that individual who actually ran a hotline.
Okay, then I would get rid of 3.
For your recommendation.
All right, we got something in blue off our list.
Section 37 establishes a process for allowing the informal advice, and that it provides the same. So I think we would remove that if 36 being removed. 36.3. And this one, I think this is the one you were concerned about, Council Chase. It confirms that the requester seeks a public meeting or hearing in a proceeding related to a confidential advisory opinion, that it's not subject to the notice of the open meeting laws, but you were concerned that there was some language in there that made it so it was a public meeting.
Yeah, it was when we were setting up the exclusion for the open meeting law. The language was that the commission would otherwise hold a public meeting and basically be upon our regulatory public meeting process we would establish by regulation. This is just a typographical error that it got included in the advisory opinions because they're all confidential. They need to be confidential so they can get confidential preventative advice to comply with the law. It's just a typographical error in the statute, but otherwise the provisions of this bill section are appropriate.
Okay.
Just needs a little change in language.
Any other questions on 38? Okay, 41 through 42. Confirm the ability to conduct a preliminary investigation into jurisdictional facts to assist the commission with understanding whether it has jurisdiction, and allows the commission to consider those good cause extensions for the jurisdictional determinations. And so right now there's kind of an interesting question about how much we can do as staff in investigating on jurisdictional determinations. There's some subject attorneys out there that would like to say you're not permitted to do any fact finding. You just have to do whatever is on the complaint and roll with that. Currently, we haven't issued any like subpoenas or done any formal investigation procedures. We have made some public records requests, so we have hunted stuff down, online that's publicly available. And so this would just confirm that there's an ability to conduct that initial investigation to get enough information to make a solid recommendation
Yeah,
to the commission.
I think this is a good thing, because I mean, otherwise, if you can't get enough information, then we could be initiating investigations and full process without, when you don't need to do that.
Yeah, and I've had interesting conversations recently with the associate counsel asset too, where, well, to what extent do you just assume what the complainant says is true for this part of the process, right? Or do you go verify that? Because it could be, you don't want to say like, oh, we're investigating you because, you're an attorney and your law firm represents these people. Like, my law firm doesn't represent any of those people. And so it just confirms that preliminary investigation stage.
Okay, you guys good with it?
I'm good with it, except once again, that third section where it starts with consider revision. I just had trouble reading that again.
Okay.
To try to understand what we were trying to do. So maybe on the next meeting, we can just look at that and make sure it's crystal clear what you're asking for. I think that where it started talking about NAC regulations, that party status of the subject of the complaint and the executive director who are already defined parties under, you just start losing me when I start reading that.
Basically, what the request is currently we have a regulation that defines what a party is to a case. And we've had some party status doesn't start until the subject actually goes past the panel stage of proceedings. Because before that, it's just the commission's own investigatory time to determine whether there's a just and sufficient cause for that case to go forward. So once a panel determination is issued, there's parties and there's party status. And why that's important, even under our current system, is, for example, the law now requires that both the executive director and commission counsel review the jurisdictional matters. If there was party status from the beginning, I would not have that authority to do it in the statute, because I would have to be separated from the proceedings. It would be a contested case basically from the get-go. So it's just a cleanup of that, because we have received recently in a case an actual motion for a dispositive motion pre-panel. Well, there's no regulation or any authority to do that, but it's a confusion because people think it's like a court case where you start and the complainant or the filer is a party. They're never a party to the case. They may be a witness. And they also believe that they can do a motion dismiss right away for whatever reason. There may be down the road reasons that the commission wants to put that process in place, but right now that's not the process this board is operating under. So that's what that clarification is, and we can work on that language for the next time. It's really an informational item because we get so many people not understanding when party status occurs. And it's the same in judicial ethics as well. There's no party status until after they serve that notice of complaint. And we have the notice of complaint coming through in this bill because we wanted to provide a more dedicated timeline. Okay, here's your complaint. It's post-panel. This is what you have to respond to and defend that's going in an adjudicatory proceeding before the commission. So that's generally what that is, Vice Chair Dufferin, and we'll get the language straightened out for you. Because that language isn't in there at this point in time, so we can add some suggestions.
Thanks for that clarification.
So there's one section of that, so 42, 43. Should be on the next page, and 44 all kind of deal with timelines. And so there was some question and pushback a little bit from the legislators last time about this good cause extension, but we think it's important to keep it in, and it passed right when the final bill was passed. But that there are when we don't obtain a waiver from subjects, we have a very tight time frame, and so this would establish a process where we could request it of the presiding officer of the review panel to get a good cause extension during the pre-panel investigation phase. And then 44 extends the review panel timeframe to 45 days instead of 15 days for a written recommendation. So these are just kind of some extra breathing room in the timeframes to do the work.
I have a question. So I know we set our review panel members, each quarter. So how do we know which presiding officer, or how do we know which review panel is going to have that case, depending on, while you're going through the investigation, I guess? And what if it's like you think it's going to go in March and it doesn't go till July? So, I mean, that's kind of fuzzy to me.
So in these cases, I imagine it would be the presiding officer of the review panel that would be sitting at the deadline that hasn't been extended yet, which is 60 days.
Yeah, it's 60 days.
After receipt of or after sending notice to the.
Is this
Yeah,
what,
I just need some clarification on that.
well, I mean, is this where we get in trouble? Continue to push these down the road? That we have these so far down the road that, I mean, you're going from 15 days to 45 days. That's an additional month, 30 days. I mean, I get that I get that we're pushed with staff and all those kind of things. But this one that specifically says, provides review panel will have 45 rather than 15 days to conclude the investigation after receipt of the executive director's written recommendation. Well, the executive director has already made the recommendation. 30-day time period to provide members of the review panel for time for questions, request additional evidence, and all those kind of things. I just think pushing it to 45 days for 15 days is too much. I think it's just pushing these things down the road that may have already been pushed down the road.
Especially since it's done, okay.
Right.
And you look at the review panels, I mean, how much time do you need after
Right.
you've had it done?
My exact point.
Vice Chair Duffrin, your thoughts?
Yeah, I don't think this happens a lot, but I think this is just a provision in there in case we need to do it. And I think when we need to do it, we probably need more than the 15 days. I don't know if I agree with Commissioner Oscarson. I actually have a note here that I was just going to suggest maybe 30 days.
Yep,
Just to,
I'm good with
Yeah.
that.
Mhm.
just as a compromise.
Mhm.
But number 43 is unlimited if I am reading it correctly. There's no deadline. It's just
Yeah,
however
and
long we need it. So that's
They really struggle with that one.
That's what gives the legislators heartburn.
yeah. So if we might want to revisit 43 and look at it, just dig a little deeper and see if we maybe need to put a timeline on that as well, just so we don't get in a position. And maybe we don't need to, I don't know, but maybe for our next meeting, you guys can look at that and see if it's worded correctly, or do we really need to, maybe we need to put a time frame in there as well.
And it's so open that the review panel.
Because a reasonable deadline may be reasonable to one person and not to another.
Yeah, set specific and reasonable deadlines. I mean, I might say, all right, you can do it in 10 days, and Commissioner Oscarson would say, I'll give you 100 days to do it.
Doubtful.
And it's interesting because since it's pre-panel, right there was just like what Council Chase was just saying is the subject can't fight it.
Right.
Mhm.
Well, on the other hand, for your consideration, we have a very short timeline to do that beginning investigation to determine if there's just and sufficient cause. Truthfully, if I was a subject, I would not waive that timeline. I would, put you to the task. And that's fine. But however, if you have a large case, like the Las Vegas Convention Authority cases we had to issue subpoenas to go to Southwest Air to get a lot of the recommendations and documents that later became public in that case. The amount of time here is insufficient to be able to do a good investigation of the facts. So there's a real pro and con on each side of that fence, because unless we receive a waiver from the subject, we cannot extend this time to get to the review panel at this point in time. If we had COVID conditions, if we had sickness in the office, if we had any other factors beyond the control of the executive director, there was no ability to extend this time. And I will say that although the language can certainly be cleaned up, that this was one of the major staff reasons to include this is because of the significant amount of pressure, and your quality is going to go down if you don't have
Yeah.
time to do it as well, which isn't fair to anybody.
So do you add time to the front end?
Well, that could be a way to do it. That's a good thought, Commissioner.
Because if you need to add time to the front end, not to the back end, because once you start the investigation, I mean, look, I'm just putting myself in a position, if I were the subject to one of these investigations, I'd want to get it, I'm certainly I'd want a fair and impartial investigation of what was going on. But if it just keeps going on and on and on and on, I mean, if we give you enough time up front, or we give enough time up front to do a thorough investigation, I think some of these timelines are gonna be okay not to do some of the things that they do. So maybe you could, with the, with my fellow, with the chair and the vice chair, I'm wondering if maybe that's an easier fix than all this other stuff.
Well, and I think it's probably more palatable to the legislators.
Yeah.
To, here's how it's kind of set instead of, all right, we'll have another extension and, and.
Yeah.
Yeah, we'll bring back some
Yeah,
options at the next meeting.
okay.
Is that viable, Brian, you think?
I think that's an excellent idea. That might solve all of our concerns. I think that's an excellent idea.
I so wish my wife were here to hear that.
Well, it'll be up on YouTube later. So.
Yeah.
Okay, so I think that takes us to 45.
Can I just make one comment, Madam
Yep.
Chair? And I've been thinking about this as we're going through all these things. The makeup of the legislature is going to be significantly different
Oh, I know.
when we come back in 2 years. I mean, there's, I can count, I think, 12 or 15 that aren't coming back or come back in different capacities or do different things. So I think that and I don't want to degrade the process because that's not the intention. But I think as concise and simplistic as we can make this for some of the new legislators that are going to be almost in some instances, maybe a majority and I don't mean that by party, I mean that by just new faces, new bodies and seats. I think this was originally a 60-page bill. Is that what we heard?
Yeah.
It's got to be much more concise than that. Because I will tell you from my personal experience, reading a 60-page bill, I depended on staff to do it. And that was only if we weren't jammed up doing other things. This would take a very low priority. So and again, I'm only trying to be honest. I think that we need to look at the volume of what this is, and we need to make it so that people can read it and understand it. Like Chair Dufferin and yourself have explained. And we need to make sure that it's as concise as we can make it without being too verbose and too long and too engaged. I mean, the bills that pass the best sometimes are, 5, 6 page bills. Russ, you've been there. You know the drill.
I like the one-page ones.
Yeah. Well, sometimes those are really bad.
Yeah, that's true. So that handles the time frame. So 45, as we shift in. We start to establish a notice process. Right now, the subject gets a copy of the complaint. They get our notice that a complaint investigation is going. And so this would kind of create a more formal notice document that could better protect the individuals filing the complaints and protect their identities. I do think too that this notice process would provide more clarity for the subject themselves, because just getting the current jurisdictional determination, it's an important jurisdictional determination, but then it doesn't really give you notice about what is going on at all. Like we oftentimes get, they get the complaint and the determination in the mail, they can't even tell from it what they really did wrong, because it's hard to, in seeing the story from the complaint. So having this notice process allows us to clearly communicate to the subject while at the same time protecting the confidentiality of the complaint.
I think it's important. I want this one in here because it protects both sides.
And a further example is we had one complaint where the identity information was removed. However, the handwriting was used to identify who filed it because it was handwritten instead of typed.
Mhm.
And this would allow us to do a typed form
Mhm.
so that handwriting or other information in that complaint would not lead to disclosure of identities that are protected.
Yes, we need that.
So that's 45 and 46 both are part of that process. 47 adds the schedule for discovery and identifies the parties. I think that helps. What Commission Counsel Chase was saying in party confusion. And a notice, so it's a procedural. Clean it stuff, it's confirming our. 48 makes the final action of the commission exempt from procedural requirements of open meeting law. So we have to go through this process where if we have like what we did today, the stipulation, there's certain, if you're going to discuss somebody's behavior and conduct, there's all these open meeting law requirements, but they're agreeing to be here anyway. And so this, I think, would allow us to be exempt from some of those when we're talking about that final adjudicatory hearing. Or other, other times where everyone's like, we all know we have to be here type of thing. Any questions on 48? 49 is more miscellaneous cleanup. 50 through 53 clarifies that we treat comparable situations similarly as practical, as it's practical to do so. And so it also, we're considering revisions to say that it can resolve cases through stipulation, deferral agreement, consent order, and be consistent in those particular resolutions.
But that.
Go ahead.
You see, I want to say this. Years past don't necessarily reflect the times now, right?
Correct.
So by doing that, do you tie yourself to previous opinions and previous things?
So currently the rule is we have to. This is adding it to be qualified, like as it's practical to do so. So this language actually does, I think what you're trying to say is like, if you have a 40-year-old case that you resolve.
Maybe different than a case today.
Right.
And treated differently.
And this.
And adjudicated differently.
Right. And so this
So I
gives
didn't
us.
read it that way, so I apologize.
No, that's okay.
A requirement for the commission to treat comparable situations in a comparable manner is qualified by practicality.
So we currently have the requirement that we treat comparable situations in a comparable manner, period.
Okay.
This adds that, as it's practical to do so.
It might be helpful, Ross, when we do our final draft of this.
Yeah.
Like we do legislation and again, with the permission of the chair and the vice chair, that we do red lines.
Yeah.
What it was and what it now is, to
Yeah.
make it more concise. I find that very helpful. Or purple language like they do in bills, new
Right.
language is in this kind of thing, and the other language is lined out or whatever. I don't know if that makes it more complicated for you, Madam
No,
Chair, or
no,
not.
we
I think it's
should-
simpler for me to read that way, because
Well,
I
we
just
need
read
to
this
see it.
completely wrong, and I feel bad about it, because I didn't have anything to compare it to.
Yeah, so my plan would be to take the decisions and discussion today, and then for the next meeting, bring back essentially a mocked up bill that shows
Mhm.
just that.
Yeah.
That's okay with you,
Oh,
the
no,
vice chair.
that's what
I don't
we
know,
want.
Brian, if you can read stuff easier that way or not. I can.
Yeah, there's a lot of work to be done when you do that, but if you want to do it, you go for it.
Well, I think it would be better, then we see what we're doing and maybe LCB won't make some moves.
This has been really helpful though, Russ. You did a great job with this.
Tracy.
Tracy did a great job with
I
it.
just put colors on it.
Give me a good-
It was a combined effort.
It
Madam
was a
Chair,
collaborative effort.
on 50 and 50-53, there's a little note there about revising revisions to confirm the commission may resolve complaint cases by stipulation, deferral agreement, consent order, opinion. I agree with all that. I think that needs to stay in there. I think we need to, I think that's a little bit separate than what the stuff above it talks about. But I think that's a really good point, that we need to be able to resolve these things and how we go about resolving these things. I don't think that's in there now.
No, it's not currently in there. Now you have to look in the particular section to see how the authority is flowing to the commission. But really, the commission should have broad powers to use any of the resolution tools that are available throughout the chapter.
I like that little comment. Thank you.
Section 54 gives safe harbor protections to the public officers and employees that are seeking preventative informal. Would we need to do this one, council, if we get rid of those other sections?
Yeah, I agree that this could be eliminated. I think we should look at the language we have previously about treating, no, it's, we can,
The separate.
yeah,
violations and
separate,
cumulative.
separate versus cumulative, and I think we can eliminate this and just make sure that other section reads like we want it to.
Again, as concise as you can make this, I think it's the best way for us to have it happen. I think there's a lot of great stuff in here, but we need to make sure we're doing the stuff we absolutely have to. We can't live without.
So that was the bulk of AB 65. And then, of course, there was Amendment 777 from the legislature. And as we discussed, there were some items of that, like not making the executive director have to be an attorney. There were a couple other ones we already discussed in those particular sections that were good stuff from Amendment 777. But the bulk of it removed legislators completely from the commission's jurisdiction and created different committees within the legislature. There were some materials provided about other states, and most states maintain that authority over those two branches. And so it's an interesting question. I think we know that there's one assemblyman who's likely to propose a separate bill that would do all of that stuff. So I don't know that we necessarily need to address it in our BDR, but if there's any direction on how we should approach the topic of exempting legislators from our commission jurisdiction and what that looks like. And I think there's an open question about if legislators are removed from the jurisdiction of the commission, then should the legislature be removed from the appointment process of the commission, since it's then just an executive branch commission. So that's some stuff to think about in terms of the impact of the amendment. And
Have you communicated with the legislator? You know who it is?
yeah, I asked him if we could provide the materials. He did. We could certainly invite him to our next meeting if you'd like to be at our next legislative meeting, if that would be helpful.
Well, I'll throw this out. And here's the thought. I mean, and we go up against it with the legislatures all the time. Some are like, they think we're trying to grab power. I mean, all we can do with them is misuse of government property, honorariums, self-dealing contracts. That's basically it. Is there a way we could just spell it out in places? And I mean, I just, in the sections that really don't come into play, that might be one way to do it.
The legislature has, in my experience, has been a self-governing body.
Yeah.
We go back to the Stephen Brooks thing, and I, personal experience there because I went through those processes with the legislature and other members as so defined. I think that this is almost something you need to discuss with new leadership when they appoint their new leadership, because they're the ones who are going to be driving that ship. Whoever the new leaders are going to be, I think that's a process that you have to a road you have to go down, because they may have very different thoughts. Again, with the different composition of the legislature, they may have very different thoughts for accountability and atonement and those kind of things that need to happen when things happen, when things that are suggested until they're proven they're not. But I think that that's you can put you can always amend this, right? You're going to put this in as a BDR. You can always amend it to do things. And that's what the amendment process is about. But I think a prudent conversation, solid, prudent conversation with new leadership to discuss this as a bill that was vetoed last year, and to see if, are they going to bring it back and suggest that they override the veto?
It's possible.
I mean, that's a possible thing too, that this may all be a moot point. But we're going to be prepared for that. And that's another discussion you need to have with leadership. I suspect that'll be known fairly quickly who that's going to be maybe even after the primary elections. But I think they're already charting that path. And so I'm encouraged by that, because I'm encouraged by the fact that dialogue could exist and could happen. And if they want to override this for whatever reason, because they passed it,
Right.
the previous legislature passed it. So those are just some thoughts.
To add to the commissioner's thoughts, I do know the veto letter had a cost analysis requesting it be performed in the interim. I don't think we've received any information that cost analysis is done.
Who's doing that?
That's the
LCB?
question. I would think it would be LCB since it was their amendment. So we reach out to them to
Yeah, find out
determine.
if they're doing a cost analysis on it. Because that'll be a big factor this next session too, because let's face the reality, some of the funds and those kind of things that have been available in the past are going to not be available. We're going to be very cost conscious, I would suspect, in what happens with the next legislative session. And I think that if I were there, that's what I would do, but that doesn't mean anything. But I think that cost is going to be a big issue, and you're going to have new chairs of money committees. It's going to be a completely different way that it's ever been done before. So, and I think it's going to be an exciting time to watch and see. But the relationships we build and the things we get out front are going to be extremely important for us anyway. We can't be waiting until the last minute for this kind of stuff like we did last time. It just kept getting pushed back and back and back by no fault of anybody's. It just was the way the session ran last time. So I'm encouraged that we can do that. I'm encouraged, Ross, I'm most encouraged that you have the legislative experience to go to these leaders and talk to them. And I'm happy to go with you, or the chair or the vice chair, whatever you want to do, to talk to them about what we need to do. I am, and that's, it doesn't do anything but help you in your cause.
Yeah, that makes sense.
And I think about what the cost would be. Okay, so they aren't overseeing thousands of public employees. And based on the number of ethics complaints we get against legislators.
There are hardly any of them.
Yeah, so what is the cost going to be? It's not
Because the
like
legislature governs themselves.
it's not like they're going to be meeting every month and have a full staff working on it. Just be like a committee that's when we have it.
Yeah, but the fiscal notes, as you well know, being in your position, can become sometimes difficult to even defend.
And they're not even there.
I could tell you stories. Anyway, that would be my thoughts, and I think that can be easily accomplished.
Well, and I think what the thing we need to make sure that the legislators know, and this would be like our talking point piece, is what does the ethics law, how does the ethics law pertain to you? These three things.
You're going to take on the role of lobbyist, Ross.
Chair.
Says you can't lobby. Yes, Vice Chair Duffrey.
So I have three thoughts on this, and two of them have already been covered, but I'm going to talk about them anyway. So the first question is, should we even be involved in deciding whether or not we're going to carve the legislature out? And the answer is no. It's not. That's not our job. We don't create law. We only amend laws. I think that this letter from the governor, which our commission counsel referenced in here, and I'll read it, says, This is what the governor had said in his letter. I firmly believe that a more robust examination of the costs and the benefits of returning to that structure should be conducted. And the structure would have been carving the legislature out 100%. So there's 37 states that have a single ethics commission based on this memo that we received in our materials that the research division of the Legislative Council Bureau did on behalf of Assemblyman O'Neill. So there's a lot of great information in there about what currently is going on in other jurisdictions. But once again, I firmly believe that this should not be included in our bill, that we carve out or include the legislature. I don't think that's really should be an issue of this bill. That's for the legislature to decide. As far as who's going to fund that, it's definitely not going to be us. We don't have the resources to do that. And the second point, which the chair made numerous times, I totally agree. We need to communicate to the legislature what it is that we actually do oversee them on, and it is very minimal. This particular bill has no new provisions that add to those powers that oversee the legislature. I think that needs to be brought out when we actually approach them. But we also really do need to clarify what is it that we do how do we oversee the current legislature? It's very, very minimal already to begin with. And I think there was a lot of confusion on that when we had our meetings with the last individuals. One individual, one legislator who had been there for many years quoted, I can quote her, and I know the chair was with me in that meeting, said, "You guys don't oversee us at all," which is not true. So there's some confusion about what it is that we do, what oversight that we do have with them. My last point is, I already made it, never mind. I'm reading through my notes. Those are my thoughts. Done for the day.
Well, and the executive director's comment about, okay, so if the legislature carves themselves out from us, what about, should they have a role in appointing? And I remember Commission Council and we were talking about that. And I said, I actually think that they should have a role, because this is an ethics commission that we're overseeing public employees, which are citizens of our state, okay? And the legislators represent them. So I think having it that way, one, it ensures that we get a commission that maintains its nonpartisanship. I think that if it was all appointed by a governor, you could end up with, or say all appointed by the legislature, you could end up with members on the commission that are not really there to do their job, just figureheads. So I think it's good to have.
The way it's done now is
Yes,
solid.
I think it's provides for better transparency and trust in the commission that way.
And I think by expressing support for that process to the governor and to the legislature,
Yes.
it solidifies the fact that we believe that that's the best way to do it.
Yeah, that not one branch is controlling this commission, which I think is very important. Well, those are my comments. Any other comments? I know we brought up why don't we have, why can't convicted individuals file ethics complaints? Comments, thoughts?
I think that was explained very well, and probably would overwhelm the process when there's already a process in place for that to happen.
Vice Chair?
Yeah, I don't think that's necessary at this point.
Yeah, I mean, we've got so much in this bill, we can't be adding to it.
Yeah, I heard it from two different people earlier, Commissioner Oscarson and the executive director, and especially Commissioner Oscarson, who sat in the legislature and knows us better than anybody else. the more concise we make this, and clear and concise we make this bill, the better off everybody's going to be.
Absolutely.
Okay, so I think,
That's the
I don't
end of your
know.
Presentation.
Yeah, that's the end of the presentation. I don't know if there needs to be any action or if I just
Well,
take the
I'll
direction.
just go and say, I'll ask for a motion that the recommended changes,
You could direct staff just to move forward with the things that we've discussed or some of
you
that.
always want a motion.
Yeah, you can just say I move to direct staff to
Mhm.
proceed with the recommendations as we indicated today and bring back at our next session
Right,
the information for us to consider would be your motion. That would be fine.
okay. Who wants to make a motion?
I'll
make
I'll
that
make
motion.
that. I'll make
I'll
that
do the
motion.
second. You do the first, I'll do the second.
Yeah. all
I'll
right,
make
so
the
it's like-
motion that we make, basically what the commission council just said, that's my motion.
Okay,
Not
Second.
basically, but exactly what she said.
I second with an addendum that Chair Dufferin has to read every word of it.
all right,
I'll rescind that part of the motion, Madam Chair.
all right, thank you. All right, all those in favor say aye.
Aye.
Opposed, all right, motion carries. Yeah, I think that, all right, now, commissioner comments. Any comments from the commissioners?
I'm commented out.
Okay, all right, with that being said, is there any public comment?
Madam Chair, there's no members of the public here. Executive Assistant Pedrosa, do we have any members on Zoom wishing to comment?
We have no members of the council.
Thank you,
Alright.
Madam Chair. We have no public comment today.
All right, and I'll entertain a motion to adjourn.
I make that motion.
I second that motion.
All right, all in favor say aye.
Aye.
Opposed? All right, motion carries. Meeting is adjourned. Thank you guys very much, and thank you to staff for all the work put into this.
What?
It
Do
really helped in reviewing the document.
we want to set our next meeting? while we have
Sure,
everyone?
yeah, sure, let's set our next meeting.
Oh, do I have to sit down?
Let's do that.